Every time you buy a packet of milk, a loaf of bread, or even airtime, you enter into a contract of sale of goods, either knowingly or unknowingly. I will take you through the law of sale of goods, and by doing so, I will define to you what is a contract of sale of goods. What are the various types of goods that we have? The various types of sales that we have. What is a condition? What is a warranty? And finally, I will define for you caveat emptor. Let me start by explaining what is a contract of sale of goods. And a contract of sale of goods exists when one party, referred as the seller, agrees to transfer the ownership of goods to another person referred as the buyer. For that to happen, there must be two parties, a buyer and a seller. And there must be a property that is the subject of this contract. And of course, there must be a price. The reason why there must be at least two parties is because a person cannot sell to themselves. The reason why there must be a property is because when you speak about Sale of Goods Act, we are talking about a property and not a service. Services are legislated or governed under the law of contracts. And this property that we are referring to about, it must be a movable property. Remember, immovable properties are like land and buildings. Those ones are transferred or are dealt with under the Lands Act. In terms of the property that we are talking about, it is something like a car, it's a piece of furniture, computer, electronics, you can name all those. Now, price is very key when it comes to the contract of sale of goods. And this price must be measured in terms of the monetary value. You cannot say that price is something else. For instance, if party A and party B decide to exchange goats and cows, that is a barter trade. And barter trade is legislated or is governed under a different piece of law. Now that we have discussed what is contract of sale of goods, I want us to ask ourselves what are the conditions that must exist for a contract of sale of goods to prevail. Number one, there must be a property because it is the essence of this contract. Number two, individuals, parties. And a person cannot sell to themselves. But if I have a company that I am the only shareholder, in fact, I can sell to myself because my company and myself, those are two different entities in the eyes of law. I can sell to my wife, I can sell to my children, I can sell to my siblings, but I cannot sell to myself. So the essentials of a contract of sale of goods to happen, a property must be there, there must be two parties, there must be price, which is the consideration. If there's no price and transfer of goods happen, and party A was owning a Prado and transferred this Prado to person B, that kind of an arrangement is not governed under the contract of sale of goods, but it is under that one can be considered as a gift. Now, there are two types of sales. One is the sale itself, and the two is the agreement to sell. And the difference between these two, sale and agreement to sell, is the timing of the change of ownership. Under sale contract, the ownership of goods changes hands immediately. But under agreement to sell, the ownership of goods does not change hands immediately, but does so at a later date in future. Now, there are various differences between the two, and I will discuss them in terms of the risk, in terms of breach, and in terms of insolvency. Always remember that a sale contract, it is an executed contract, meaning that both parties are said or purported to have executed their obligations with reference to that contract. But an agreement to sell, it is an executory contract, meaning that either of the parties or both parties are yet to execute their duties with reference to that contract. Now, a sale contract, the moment it has been executed, it doesn't matter who has the possession of the goods. It doesn't matter whether the buyer has paid for those goods or not, but the ownership of those goods changes hands immediately. We can have party A and party B, A being the seller and B being the buyer, and they transact about a property that is in Mombasa, that is maybe a car, and both of them are in Nairobi. The moment they sign that sale contract, the ownership of that car that is in Mombasa changes from the seller to the buyer. And in case that car is damaged, maybe through accident, the loss is on the buyer, not the seller, because the ownership of goods changed hands immediately. In fact, even the insurance that is on that car should be changed from the seller to the buyer, because at that point, the seller has no insurable interest on that property. But on the other hand, when we speak about the agreement to sell, and let me discuss about the same car, that party A is the owner of a car that is in Mombasa and party B wants to buy that car, but not immediately. They enter into an agreement to sell contract. What that means is that the ownership of that property will not change hands immediately, but at some point in future. And therefore, the risk still remains with the seller. And they enter into a contract. For instance, they say, I will sell this car after 6 months, and it is a contract. But the ownership of that car will change hands after that period of time. So the risk when it comes to a sale agreement, it is with the buyer. But when it comes to agreement to sell, it is with the seller. The question is, what happens when there is a breach? And breach can happen in two ways. When it is coming from the seller and also when it is coming from the buyer. Let's look what happens when the breach is triggered by the seller. So the seller, a sale agreement, the seller has refused to deliver the goods to the buyer. In that case, the buyer has a remedy of suing the seller to be forced by the court system to deliver the subject goods. It could be a car. We had agreed that Party A had agreed to sell a Prado for 1 million shillings to Party B. But then Party A later realizes that the price was undervalued, and therefore he refuses. As long as the sale contract was executed, Party B can sue Party A to execute their duties. And that means they will be forced to deliver the car to Party B. However, if it was an agreement to sell that was signed, Party A agreeing to sell to Party B the same Prado for 1 million shillings 6 months later, Party B, even if Party A refuses to deliver the car, Party B cannot force Party A to deliver the car. Even if they go to court, what they can be awarded is compensation for the damages. And let me put it into the right perspective so that it is clear. Let me use a bag of maize, that there is a farmer and a manufacturer. A farmer and manufacturer, both of them enter into a contract that the farmer will deliver a bag of maize to the manufacturer at the end of the year. But at the end of the year, and agree at this point that the price, the consideration will be 1,000 shillings. So the farmer at the end of the year, he is obligated to deliver a bag of maize to the manufacturer, and the manufacturer is obligated to pay for it. So under the agreement to sell, the Manufacturer cannot force the farmer to deliver this bag of maize at the end of the year, but he can sue the farmer for the damages that he is likely to suffer. This is what I mean. That if the bag of maize in December is costing 1,100 shillings and the farmer had promised to deliver it at 1,000 shillings, it means that the manufacturer will pay for this bag of maize 100 shillings more. And that's what he should sue the farmer for. That is to be compensated for the damages that he has incurred. That is in the case that the seller has breached the agreement. And I've discussed in both cases for the sale agreement and agreement to sell. For the sale agreement, this buyer can force the farmer to deliver the actual bag of maize. But under the agreement to sell, the buyer can only sue for damages. What if it is the buyer who is breaching the agreement? Again, it depends whether it is a sale agreement or it is an agreement to sell. If it is a sale agreement, the seller can sue the buyer for the full price. That the buyer would be required by the court to pay the full amount of money that was agreed upon. If it is a car, the story about a Prado, Party A had agreed to sell a Prado for 1 million shillings to Party B. But Party B, upon receiving the car, which he had an option of checking before even signing the sale contract, they realized that the engine is not in good condition, and therefore they refuse to pay the seller. And if it is a sale agreement, the seller can force the buyer to pay the full price for that Prado. However, if it is an agreement to sell, the seller can only sue for the damages. Assuming the buyer has refused to honor his part of bargain, and the seller is required now to sell this Prado to another person, and this other person decides or agrees to buy the Prado for a lesser price, let's say 900,000, and therefore the seller goes or suffers a loss of 100,000. That is the damage that he should seek to be compensated by the buyer, because the buyer had committed to buy it at 1 million shillings. And that's what we are referring as the seller seeking compensation for damages. Now, what would happen if there is a case of insolvency? And insolvency happens when one person is declared by the court to be bankrupt. And now this case, we are interested with the insolvency of the buyer. And two ways. We are dealing with it under the sale agreement, and number two, under agreement to sell. If this buyer becomes insolvent under the sale agreement, after the sale agreement or sale contract has been signed, the seller is obligated to deliver the good to the buyer, knowing very well that the buyer has no capacity to pay for it because the buyer has already been declared bankrupt. But it is a requirement of law that the seller must deliver. What would happen in such a case? When someone is declared bankrupt, the court appoints someone referred as the liquidator. The work of the liquidator is to consolidate all the assets of the bankrupt person and then consolidate all the liabilities that the bankrupt person is owed. And he sells these assets so that he can pay for these liabilities that the bankrupt person is owed. So the seller, under the sale agreement or under the contract of sale, is supposed to deliver the good and then to be enlisted among other creditors who will be looking forward to be compensated once the properties of the bankrupt person are sold. So under the sale agreement, it is very tight, very, very challenging for the seller because the seller has to deliver. But if it was agreement to sell and the buyer becomes bankrupt, the seller has no obligation to deliver the good to the buyer because the ownership had not changed hands. And that's the good thing. The seller will avoid that loss. So in case of insolvency, you know what to do if it is whether it's seller agreement or agreement to sell. Now, there are three types of goods: existing goods, future goods, and contingent goods. I will start with existing goods. And these are goods that are physically present or existing at the point the contract is being signed. That I'm selling you a Prado and you can see this is the Prado. I'm selling you a piece of furniture. You can see it and you can touch it. I'm selling you some electronics. You can see them. They are existing at the time the agreement is being signed. However, for future goods, these are goods that are not existing at the point the agreement is being signed. We have two types of existing goods: specific goods and an ascertained good. Specific good is a good that I can tell you, this is the phone that I'm selling you. This is the laptop that I'm selling. It is specific. If it is a car, it even has number plates. Now, an ascertained goods, I could be selling you a bag of maize, and my store is full of bags of maize. So I tell you, I will sell you one bag of maize out of 1,000 bags that I have. So I have described, but I have not specified, but that would still carry the day as long as the contract of sale of goods is concerned. So either existing can be either specific or unascertained. For future goods, these are goods that are not existing at the point the contract is being entered into. You can go to a tailor and you want a suit for your graduation or maybe for your birthday party or for your wedding, and you tell the tailor, I want this kind of a design, and the tailor will start preparing that suit the moment some deposit, and that's what we are referring as a future good. Future goods are basically a product or are used under the agreement to sell. Because agreement to sell, remember, we said this is when goods, the ownership in goods changes hands in a future date or at a future time. Therefore, future goods is the one that is mostly dealt under the agreement to sell. Though even existing goods are used under the sale agreement to sell, but normally it is about future goods. Now, the third type of goods is contingent goods. Contingent goods is actually of future goods, and these are goods that are not existing at the point of the signing of the contract, and this contract could be a sale contract or an agreement to sell contract. But now contingent goods, they are not existing at the point the agreement is being signed, and they are conditional to some other events happening in future. That's why they are a subcategory of future goods. For instance, I can tell you, I will sell you a piece of land that is located in Murang'a once my father gives it to me. Once I inherit that piece of land, that's when I will sell it to you. Or maybe if it is a student, I will say, if I manage to graduate at the end of this year, I will sell this laptop because I will no longer be using it. That is a contingent good. And by the way, that's not a good idea. For students, don't sell your